Good morning, class. We're going to start our discussion today on preliminary offenses. And we're going to start by discussing the offense of attempt. Now, the first thing we need to note is that mere intention alone is not criminal. So the fact that you sat in the corner of your house and you feel that you want to commit an offense, but it's in your mind, mere intention alone is not criminal. But when a man begins to put that intention into effect, he may be guilty of an offense even before he has achieved his aim. So when a person attempts to commit an offense, it is an offense. Now, attempt is an offense that occurs when a person comes very close to carrying out a criminal act and actually intends to commit that act but does not in fact commit it. The essence of the offense of attempt is, in legal terms, is that the accused has failed to commit the actus reus of the full offense, but has a direct and specific intent to commit that full offense. So it means that he has started carrying it out, but he was not able to commit the full offense, but he had the intention to commit the full offense. That is the offense of attempt. Now, Section 4 of the Criminal Code provides for the offense of attempt. Now, according to that section, Section 4 says that when a person intends to commit an offense and he begins to put his intention into execution by means adapted to its fulfillment and manifested his intention by some overt act, but does not fulfill his intention to such an extent as to commit the offense, he is said to attempt to commit the offense. Now, it is immaterial whether the accused was prevented by circumstances beyond his control or independent of his will, or that he desisted of his own motion from further prosecution of his intention, or that by reason unknown to the accused, it was even impossible to actually commit that offense. It's regardless of all those parts, he will still be guilty of the offense of attempt. Now, in the case of Har and White, the accused put potassium cyanide into the drink of his mother, intending to kill her. His mother was eventually found dead shortly afterwards, but medical evidence showed that she actually died not of the poison, but of heart failure, and that the quantity of the potassium cyanide in that drink was not sufficient to kill an adult. He was charged with attempted murder. The court held that though he could not complete the full offense, but he had the intention and he had started carrying out acts that would lead to the fulfillment of that full offense, and so he was guilty of attempted murder. Now, let's look at the requirements of the offense of attempt. The first one talks about the mental element, which is mens rea. We have always told you that for an offense to be complete, it must have the physical element, which is actus reus, and the mens rea, which is the mental element. Now, so for the offense of attempt, there must be an intention on the part of the accused person to commit that offense. That is the mental element. Now, the intention required is that the accused desire the consequences that should occur after his actions. That is what we mean by mental element. Now, in Ozuluke and the state, the accused had a knife on him and was engaged in a fight with the knife. He only made a small mark on the body of his opponent. Now, he was charged to court for attempted murder. Now, the court held that no, that was not attempted murder. That if he actually attempted murder, he would have stabbed the opponent on other parts of the body, which would show that he actually intended to commit murder. Also, in the case of Haran Seidu, here the accused was found with a girl of 11 years. She was found sitting on the accused's lap, who was wiping her laps with a cloth, and it was found out, on examining the cloth, they found out that the cloth contained human semen. Now, human semen was also found on the girl's private part, but there was no evidence of penetration whatsoever of the outer part of her private part, or even any further penetration. Now, the court held that the accused did not have the intention to rape her, but only wanted to obtain sexual gratification without penetration, and he was therefore not guilty of attempted rape. Now, so it's the fact that you have an intention is very important, but how far have you gone is what will help the court to determine whether this was what you intended to do or this was what you intended to do. Now, there are so many ways the court can determine whether somebody had an intention to commit a particular offense which he eventually did not commit. A particular act may or may not be criminal attempt, depending on the intent with which it was done. Now, intention can be proved in so many ways, as a matter of fact, or it can even be inferred from the actions of the accused. For example, if Mr. A shoots Mr. B in the head, that's one scenario. And another scenario, if Mr. A shoots Mr. B on the toes. From these two scenarios, it can be inferred that in the first scenario, Mr. A intended to commit murder. But in the second scenario, he merely intended to maim or disfigure or cause bodily harm to Mr. B. So to infer intention, it has been said that one can look at, number one, the nature of the weapon used by the accused, the nature or extent of violence used. Now, the situations of the parties, the part of the body hit, where we talk about offense against the person, or the situations of the party, which party has the stronger power, or which party has a weapon more grievous than the other. So these are the things that the court looks at to determine whether the other party had an intention to commit a particular offense. Now, that's the first requirement, mental element. It must be shown that the accused actually intended to commit the offense we're talking about. Now, the second requirement is that the accused must have commenced the execution of his intention by means adapted to its fulfillment. It means that the accused must have started carrying out some acts which will lead to the fulfillment of that offense we're talking about. Now, in Har and Ofyong, the accused entered the room of the complainant, took off his clothes and expressed the desire to have sexual intercourse with her. And he even held her shoulders. But he didn't do anything further. Now, he was charged to court for attempted rape. Now, the court held that from what the accused had done, it fell short of rape because there was no force involved. He did not push the accused. He did not struggle with the accused. And that there was even no indication that if he went further, he would not get consent. And thus, he was not guilty of attempted rape. Now, in Har and Robinson, a jeweler insured all his jewelry one day and tied himself to a chair and hid the jewelries and then called the attention of the police to say that they were stolen so that he could claim insurance money. Now, it was held that it was not attempt since the insurance form was not filled. He did not send the insurance form to the insurance company and he did not even notify them of any theft with regards to the jewelries, and so it was not attempt. Now, in Comer and Bloomfield, that's another case. Here, the accused was driving and he got into an accident and his van was badly damaged. Now, he went and hid the vehicle in the bush, in the wood, and reported to police that it was stolen. Now, he now wrote a letter to his insurance company making inquiries whether he could claim on the stolen vehicle and that they should furnish him with further information. The court held that it was still not attempt because the fact that he requested for information did not show that he intended to obtain money by fraudulent means, or that he intended to obtain money by deception. Now, in Awoshik and Inspector General of Police, the accused was a salesman in Leventis Motors and was entitled to commission on every vehicle that was sold. He filled a cash voucher on which he could claim the commission after approval by the sales manager and the chief accountant, and then present it to the cashier for the payment. Now, he forged the manager's signature. The court held that he was guilty of attempt to obtain by false pretense because he had already started carrying out some actions that would lead to the fulfillment of that offense by forging the sales manager's signature. And it shows that he was aiming at obtaining money by false pretense. You can also see the case of DPP and Stonehouse. All these cases actually showed at what point the court would determine whether the accused has commenced the offense by some actions that will lead to its fulfillment, or whether it has still not shown that the accused has commenced actions to fulfill the offense. Now, you have to note that there's a difference between attempt and mere preparation. Preparation consists of devising, arranging means, measures necessary for the commission of the offense. For example, if somebody says that, I will kill this man today, and he starts filing his cutlass, he has been filing the cutlass for like 3 months. Now, the question will be, because he said he was going to kill the accused and he has been filing his knife, does that amount to attempt? No, that is just mere preparation. Now, preparation is just devising, arranging means and measures necessary for the commission of the offense. That is different. But attempt, because preparation is not an offense at all, but attempt is the offense. Now, attempt, on the other hand, is that you have started commencing execution of the intention by means adapted to its fulfillment. You have started carrying out acts that will lead to the fulfillment of that offense. So attempt is trying to commit an offense, but you failed. Whatever is responsible for your failure, regardless, it's immaterial. But you have started, you already tried to commit that offense, but you failed. So the attempt must have gone beyond mere preparation. That is what it means. Attempt must have gone beyond mere planning or preparation. Now, in the case of Boyle and Boy, it's an English case. Mr. D damaged the door of a house with a view of entering the premises and with intent to steal. He was charged with attempted burglary. Now, the court held that D intended to enter the house and steal and to commit the offense of attempted burglary. By breaking down the door, it showed what his actions led to. It pointed to only one thing, to steal. And that was, he was guilty of attempted burglary. The court further held that in breaking down the door, D did more than preparatory act and was guilty of attempt to commit burglary. Now, that's the first requirement we have discussed, talks about the mental element as the intention of the accused to actually commit that offense. The second one talks about the accused as started carrying out some actions which will lead to the fulfillment of that offense. Now, the third requirement is that the accused must have manifested his intention by some overt act. When we talk about overt act means something that is obvious to the eyes, evident to the senses, especially the sight. So obvious to the understanding, and it means that it will show something clearly and to make something clear and made plain. So overt act means that the accused must have manifested his intention by carrying out some actions which will be obvious to the sight. Everybody will see that, okay, from what this person has done, this is what he's trying to do. This is known as the proximity test or the equivocality test. Now, the overt act must sufficiently be proximate sufficiently proximate to commit a complete offense to constitute attempt. When you say something is proximate, it means that it is very close or near to something. That's the proximity of something to another thing. There are two theories that have been put forward to determine whether the actions of the accused is overt enough to show his intention. Now, there's this Pack-B's theory, which was established in the case of Hara and Eagleton. Now, the theory says that the acts that are immediately connected to the offense would amount to attempt, and the acts that are remote, that is far away, leading to the commission of the offense will not amount to attempt. So when somebody does an act that is really close to a particular offense, you know that this is what he's trying to do. Then that is the proximity test. But where it does something that is remote, it's far away, that doesn't have any connection with the offense we're talking about, then it will not be attempt. Now, the second test talks about the cinematography test. Now, this test says that all you need to do is put all the actions of the accused on a screen and end it at the point where he was arrested. And then you ask a reasonable man, to what end is the actions of the accused directed at? It is the answer that the reasonable man gives that will determine whether there was an attempt or not. Thus, the steps taken by the accused must have reached a point when they indicate beyond reasonable doubt that what he's trying to do, that this is what he's trying to do, which points at the end to which his actions were directed. If the steps were directed towards more than one end, then the accused has not yet done enough to amount to an attempt. So for the cinematography test, it says that once you pick the accused, all his actions, you stop it at where he was at the point where he was arrested, and you ask a reasonable man, where do you think his actions were directed at? If it points at so many options, then he has not done enough. But if it only points at a particular end, aiming at just a particular end, and it's obvious, we don't really know that this is what he's trying to do, then he has done enough to amount to attempt. Now, in the case of R. and Robinson, Supra, that we discussed earlier, there could be so many reasons why he tied himself to the chair. There could be so many reasons. He might be an actor. There could be so many reasons why he tied himself to the chair, because he has not done enough to point at him trying to obtain money by false pretense. Also, in R. and Ogumogu, here the accused broke his handcuffs. He was in prison, and he was trying to escape. The court held that from his actions, he was attempting to escape, because the breaking of handcuffs was adapted to escape and points to only one end. He was trying to escape from prison by breaking his handcuffs. So the court held that he had done enough to show that it was an attempted prison break. Now, the last requirement, we've talked about mental element, the intention of the accused to commit the offense. We talk about the commencement of actions that will lead to the fulfillment of the offense. Now, the third requirement says that the actions of the accused must be so obvious to show his intention. that this is what he was trying to do. And we've discussed the two theories. Now, the fourth requirement talks about the fulfillment of the intention must fall short of completion of the offense. So it means that the accused must not have committed that offense. If he commits the offense, then it is no longer attempt. It will be charged with the full offense. So this means that for an offense to be an attempt, the full offense must not have been committed. That's why it is attempt. You attempted it. You didn't do it. Once the offense has been committed, it is a full offense and not an attempt. You can also read section 95 of the Penal Code, which provides also for the offense of attempt. Now, let's move further. Let's talk about attempt to procure, which is what we refer to as incitement under the criminal law in the United Kingdom. Attempt to procure is incitement. Now, according to section 513, subsection 1 of the Criminal Code, anyone who attempts to procure another to commit an unlawful act, and that other person agrees to do it, the procurer will be deemed guilty of attempting to commit the offense, even if the other person does not agree to it. Here, the words of procurement only suffice as attempt to procure. So, unlike what section 4 says, that you must have the intention, started carrying out the act, and you must have done something which is obvious that this is where you are going to, and then it must fall short of completion of the offense. But for attempt to procure, it says that according to section 513 of subsection 1 of the Criminal Code, where you procure or counsel another person to commit an unlawful act, and that other person agrees to do it, even if he does not agree to do it, the procurer will be deemed guilty of attempting to commit that offense. It means that he has not done anything, he just agrees that, okay, I will do it. You are guilty of attempt to procure. You are guilty of incitement. That's what it means. So you're procuring another person to commit an offense, and the person says, okay, I will do it, makes you guilty of attempt to procure. But one thing you need to note is that the procurer will only be guilty if he himself were to do the act or make that omission. He will be guilty of the offense. So for you to be guilty of attempt to procure as a procurer, you must be capable of committing that offense under the law yourself. For example, section 30 of the Criminal Code says that a boy under the age of 12 years old cannot commit rape. So if he procures another person to commit rape, if he procures another person, counsels another person to commit rape, and the person agrees, he cannot be guilty of attempt to procure, because under the Criminal Code, under section 30 of the Criminal Code, it's a legal impossibility for a boy of 12 years and below to commit rape. So since he cannot be guilty himself of that offense, then he cannot be guilty of attempt to procure. So for you as a procurer to be guilty of attempt to procure, where the person agrees alone, he has not started doing it, he agrees to do it, or he even doesn't agree to do it, or if there's evidence that you procured him to do something, it's attempt to procure. But you yourself for you to be guilty of attempt to procure, it means that you must also be able to be guilty of that offense under the law if eventually you carry it out yourself. So if you are not going to be guilty, if you don't have the legal capacity or the legal capacity to be able to carry out that offense by reason of immaturity or whatever reasons, then you cannot be guilty of attempt to procure according to section 30 of the Criminal Code. Now, the second requirement says that such a procurer will be liable to the same punishment as if he had himself attempted the offense he procured. So it means that if you counsel another person to commit rape, your punishment will be the same as if the person attempted to carry out that rape itself. It's not anything less. So if you procure another person to commit rape, and the person agrees to do that, it is attempt to procure. But if for example, the punishment for attempted rape is 10 years imprisonment, now your punishment will also be the same as if you attempted that offense yourself. So it's not going to be less. So such a procurer will be liable to this punishment as if he had himself attempted the offense procured. So attempt to procure is similar to the English case of incitement, like I mentioned earlier. Once a person incites or procure another to commit an unlawful act, such a person is guilty of attempt to commit such an offense himself. The other party does not have to do anything. You yourself will be guilty of an attempt to procure that offense. You are going to be guilty of attempt to commit that offense yourself. It's what we refer to as attempt to procure. Now, section 513, subsection 2, also provides that a person in Nigeria attempted to procure another person to do something unlawful outside Nigeria will also be guilty of the offense of attempt to procure, if such a person will be guilty of an offense under the laws of that place where he's procuring that person to commit an offense, and also provided that he will be guilty under the laws in Nigeria. So if such an unlawful act is an offense both in Nigeria and in the place outside Nigeria, he will be guilty of attempt to procure. So where you procure somebody to commit an offense, but the person is outside the country, the rule is that thing you are attempting that person to do an offense in Nigeria? Yes. Is it an offense outside Nigeria? Yes. If it's an offense, you will be guilty of attempt to procure under section 513 subsection 2 of the criminal code. Now we have come to the end of our discussion on the offense of attempt. I want you to listen to this video attentively and also read the note that I've sent ahead of this video, and then our next class I will address any questions on the topic of offense, on the topic of attempt, which as an offense. I beg you, please listen and read your book. Please stay safe. Thank you very much.